entered the room?
I object. I object to your assumption and presumption that I'm a Mr. Crispy, a Timmy Leo Crispy, a Timmy L Crispy. That is a trust.
Judge.
Okay, thank you, sir. We're going to mute you now, sir. I'm going to explain to you. We're going to mute you now, sir. Very good. I am Judge Lopez. I'm going to be presiding over this proceeding today. This is the state and the individual who I'm referring to as Timothy Crispy appears on both the Cumberland and Gloucester calendars. I'm going to call both cases now. From the Cumberland calendar, the state of New Jersey versus Timothy Crispy. This is under warrant 2026-995-0601. Under the Gloucester calendar, it appears as state of New Jersey versus Timothy Crispy under warrant 2026-264-0814. Counselors, their appearances for the record. I'll start with the Cumberland state.
Good afternoon, Your Honor. Chris Kelleher on behalf of the state.
Christopher Connor, Officer of the Public Defender, on behalf of the defendant.
And from the Gloucester calendar.
Good afternoon, Your Honor. Assistant Prosecutor Christopher Ammon on behalf of the state as well.
Christopher Connor, also at the Public Defender's Office still, on behalf of the defendant for the Gloucester matter also.
All right. And so I know you do. It's been placed on the record. The purpose of this hearing is to advise you of the charges that were filed against the individual known as Timothy Crispy, to advise you of the maximum penalty should you be convicted of those charges, to ensure that you have been advised of certain rights that you have, and to advise you of your next court date. As it relates to warrant 2026-995-0601, you were charged with 3 fourth-degree offenses: cyber harassment, a retaliation for past official action, and harassment while imprisoned. For each one of these 4 fourth-degree offenses carries a maximum of 18 months in jail and a $10,000 fine. Under the Gloucester warrant, which I will reference, it is warrant 2026-264-0814. You were charged with a 3rd-degree cyber harassment. 3rd-degree offenses carry a maximum of 5 years imprisonment, a maximum fine of $15,000. It is my understanding that you did not have an opportunity or to watch an informational video, but you're entitled to know certain rights that you have. And at this time, I'm going to advise you of those. You are presumed innocent unless the state can prove the case against you beyond a reasonable doubt. You have the right to remain silent. Any statements that you make may be used against you. You're being represented by an attorney from the Public Defender's Office for this proceeding only, though you may qualify for continued representation. I know you object, and I know that you did not submit to a 5A application, but this attorney has been assigned to represent you for this proceeding only. If you cannot afford a private attorney, continued representation would require you to submit to that application for the. I know you do. I know you do, sir. Thank you. Please be aware that the public defender representing you today may not be your attorney after your case proceeds to the court that will ultimately hear your matter. If you are not a United States citizen, and if you plead guilty to or convicted of certain offenses, it may result in you being deported from the United States and may prevent you from being readmitted to the United States if you leave voluntarily, or may prevent you from ever becoming a naturalized American citizen. You have the right to seek the advice from an attorney about the effect a guilty plea would have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless a prosecutor has filed a pretrial detention motion or you have outstanding detainers that cannot be resolved today. If the state has filed such a motion, your case will be heard at a later date to determine whether you can be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offenses. You will have the right to an attorney. If you cannot afford an attorney, one may be appointed to you. You will have the right to testify, to present witnesses, to cross-examine witnesses who appear at the hearing, and to present information by proffer or otherwise. Should you choose to testify at the detention hearing, your testimony would not be admissible against you on the issue of whether you were guilty or not guilty, but your testimony may be admissible related to pretrial release. I know you do. Violations of conditions of release or perjury or for the purposes of impeachment. Under the court rules, the state can request a 3-day postponement of that detention hearing. You can request a 5-day postponement of that hearing. While awaiting the hearing, your commitment to the county jail would continue. If the state withdraws this motion before the hearing, you would be brought back to court and released on your own recognizance or with conditions of release. You have been charged with indictable offenses, which means you have the right to a hearing as to probable cause. You have the right to an indictment by grand jury and the right to have a trial by jury. You may also choose to waive an indictment or a trial by jury. If you choose to waive a trial by jury, you would be tried by the court. In that instance, a judge rather than a jury would determine whether you were guilty or not guilty. You may be eligible for certain diversionary programs. The pretrial intervention program may be available to you. There's a $75 application fee for that program, which can be waived if you're found to be indigent. You may be eligible for the recovery court program. In order to be considered for that program, you must submit a separate application. Some counties have the mental health diversion program for which you may be eligible.
mentally
If you are eligible, a treatment provider will contact you while you are in jail or upon your release. Your court staff or your attorney can direct you to the relevant information about these programs. A special note for military veterans, veterans of the United States military, a program called the Veterans Assistance Project exists to provide veterans with referrals to community-based resources for services related to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible mentoring by another veteran. In addition, you may qualify for the Veterans Diversion Program. Our court staff can provide you with a brochure describing the program and an application for both programs. Court staff can also help you in completing the application. As I just advised you, sir, you cannot be detained today unless the state has filed a motion seeking that you be detained pending the resolution of these charges. Upon my review of both the Cumberland and Gloucester calendars, the state has filed these detention motions on both those warrants, which means, sir, you cannot and will not be released today. There's nothing you can say or that your attorney can argue on your behalf that's going to change that fact for today. Sir, there are detention motion hearings that have been scheduled. As it relates to the Cumberland matter, a detention motion hearing is scheduled before Judge Arbitier on July 21st. As it relates to the Gloucester matter, a detention motion hearing has been scheduled before Judge Smith on the same date. The courts will be able to coordinate which hearing will come first so that you are able to appear for both. Anything from the state in Cumberland as it relates to this matter that you'd like to place on the record, sir?
Nothing further, Your Honor. Thank you.
Anything from the state as it relates to the Gloucester County matter?
No, Your Honor.
All right, Mr. Kona, anything you'd like to tell Mr. Crispy?
Judge, since he didn't fill out a 5A, the court can't appoint us to represent him. So it doesn't look like we're going to be representing him because I doubt he'll start getting cooperative on the 5A. So there's really nothing for me to say to him.
All right, very good. All right, that concludes this proceeding, sir. We're going to disconnect now. Good luck to you on your detention hearing.